Hello, and welcome to AIM International's preparatory tutorials for the Information Certification exam. I'm Steve Weissman, Principal Consultant at Holly Group and a certified AIM training instructor in the realm of content, process, and information management. I'll be your guide as we review the exam's major domains of expertise, and I'll tell you all you need to know to earn that passing grade. Today's subject is records management, a key part of this special certification, which AIM created to support you as you solve your organization's existing information-related problems and plan for its future. For 60 years, AIM has been the leading nonprofit association helping users understand how to best manage documents, content, records, and business processes. This module is part of the Secure and Preserve Knowledge domain, one of 6 within the certification program. In it, we'll cover some of the key regulatory and jurisdictional factors to be mindful of when engaging in records management, especially in the arenas listed here. A phrase that is much bandied about, regulatory compliance, refers to the effort to ensure organizational personnel are aware of and take steps to abide by laws and regulations relevant to their use of information and information technology. While this sounds straightforward enough, there are usually multiple regulatory authorities to deal with, different geographic jurisdictions to navigate, including international ones, and industry oversight bodies as well. These all put their own spin on how and how long records are to be created, managed, and destroyed, and especially in cases where repositories include information about citizens of more than one country, the impact can be dramatic, not only on records policies, but on the supporting infrastructure as well, which may need to incorporate separate databases in each country in order to be compliant. In the financial sector, regulations subject financial institutions to certain requirements, restrictions, and guidelines in order to maintain the integrity of the financial system. These may be handled either by governmental or non-governmental organizations, including, in the U.S., the Securities and Exchange Commission, the Financial Industry Regulatory Authority, the Federal Reserve System, the Office of the Comptroller of the Currency, and the National Credit Union Administration. In most cases, financial regulatory authorities regulate all financial activities, but in some cases there are specific authorities to regulate each sector of the finance industry, mainly banking, securities, insurance, and pensions markets, and in some cases also commodities, futures, forwards, and so forth. For example, in Australia, the Australian Prudential Regulation Authority supervises banks and insurers, while the Australian Securities and Investments Commission is responsible for enforcing financial services and corporations law. Adding to the fluid nature of this environment is the fact that the structure of financial regulation has changed significantly in the past 2 decades, leading to the blurring and globalization of the legal and geographic boundaries between markets in banking, securities, and insurance. The most significant piece of U.S. financial regulation may well be the Sarbanes-Oxley Act of 2002, which holds corporate top management significantly more personally responsible for the accuracy of reported financial statements than ever before. Named for its congressional sponsors, Senator Paul Sarbanes and Representative Michael Oxley, the bill was enacted in the wake of a number of major corporate and accounting scandals, including those involving Enron and Tyco. These scandals, which cost investors billions of dollars when the share prices of affected companies collapsed, shook public confidence in the nation's securities markets. The Act, by the way, does not apply to privately held companies. Sarbox contains 11 titles or sections and requires the SEC to implement rulings on requirements to comply with the new law. It also created a new quasi-public agency, the Public Company Accounting Oversight Board, and charged it with overseeing, regulating, inspecting, and disciplining accounting firms in their roles as auditors of public companies. The Act also covers issues such as auditor independence, corporate governance, internal control assessment, and enhanced financial disclosure. Depending upon the number of victims involved, a CEO can receive up to 20 years in jail if convicted of a violation, and things can get worse if destruction of records is involved. And that, of course, is why it's most important to us here today. In healthcare, the honor of most influential in the U.S. likely goes to the Health Insurance Portability and Privacy Act, or HIPAA, privacy rule, which establishes national standards to protect individuals' medical records and other personal health information, and applies to health plans, healthcare clearinghouses, and those healthcare providers that conduct certain healthcare transactions electronically. Specifically, It requires appropriate safeguards be maintained to protect the privacy of personal health information, and sets limits and conditions on the uses and disclosures that may be made of such information without patient authorization. The privacy rule also gives patients rights over their health information, including the right to obtain and examine a copy of their health records and to request corrections be made. The HIPAA enforcement rule contains provisions relating to compliance and investigations, the imposition of civil money penalties for violations of the HIPAA administration simplification rules, and procedures for hearings. Pharmaceutical companies worldwide are also subject to a variety of laws and regulations regarding the patenting, testing, safety, efficacy, and marketing of drugs, controlled on a country-by-country basis. In the United States, new pharmaceutical products must be approved by the Food and Drug Administration as being both safe and effective. Post-approval surveillance ensures that during its marketing following approval, the safety of a drug is monitored closely due to the fact that even the largest clinical trials cannot effectively predict the prevalence of rare side effects. In the realm of national security, the USA Patriot Act serves as a prime example of a key regulation to comply with. Signed into law in 2001 in response to the terrorist attacks of September 11th, it was extended in parts in 2011 and actually stands for something: the Uniting and Strengthening America by Providing Appropriate Tools Required to Intercept and Obstruct Terrorism Act. Among its many provisions are several that dramatically reduce restrictions on law enforcement agencies' ability to do a number of things that relate to information management. Perhaps most notably, 1. To search telephone, email, medical, financial, and other records, and 2. To regulate financial transactions, particularly those involving foreign individuals and entities. Among the provisions extended was one permitting searches of business records, the so-called library records provision, which will continue to be a part of the information manager's duties for at least another 4 years. Non-governmentally, broad industry regulations exist to safeguard privacy. To date, the U.S. has no single data protection law comparable to the EU's Data Protection Directive, tending instead to be adopted on an ad hoc basis, with legislation arising when certain sectors and circumstances require, like the Video Privacy Protection Act of '88, the Cable Television Protection and Competition Act of '92, the 2010 Massachusetts Data Privacy Regulations, etc. Generally speaking, the increased ability to gather and send information has had negative implications for regulating the dissemination of personal information. Many organizations are attempting to calm customers' and users' fears by updating and publicizing new and newer policies. But breaches are reported with disturbing regularity, and to this observer at least, the risk of ever more stringent regulation is on the rise, not only in the States, but especially in Europe, where such sensitivities seem to be more acute. As alluded to earlier, the specifics of an organization's approach to records management must reflect the particular requirements of the industries and geographies in which it's active. For instance, jurisdictions and retention requirements vary from country to country, depending upon their individual regulatory requirements, the existence of reciprocal agreements with other countries, and the jurisdictional authority each country accepts. In the U.S., the domestic laws governing records retention are largely federal and not state, so jurisdiction is determined mainly by the regulatory authority of the federal agency involved, rather than a department of the city or state in which the records are stored. Sometimes, however, more than one institution regulates and supervises a given industry, and that's where the fun really begins. This module covered some of the key regulatory and jurisdictional factors to be mindful of when engaging in records management in a number of industry arenas, as shown. Next, you may wish to review the section on data privacy. The material you have just reviewed is part of a broader program of study that prepares you to take the Information Certification exam. This proctored test consists of 100 multiple-choice questions and is delivered electronically by Prometric. You'll have 2 hours to complete it, and upon passing, you'll earn a professional certification that's valid for 3 years. For more information, please visit www.aim.org/certification. Thank you.